Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey, just dropping in to say we're now on Patreon. If you want to support the project, head on over to patreon.com/legallistening, where you can unlock some fun bonus content with me, Zach, and some special guests. Thanks so much for all your support. Hey, it's me today. We're pleased to bring you the long-awaited collaboration with Legal Listening and students from the British Columbia Institute of Technology. This is a project we've been working on for quite some time, and we're thrilled to finally be able to present it to you, our listeners. We're honored to be expanding our catalog to include more case summaries of decisions involving Indigenous nations. Some of these decisions we already have as full episodes, and some we don't. The ones we don't, we're working on getting recorded as full episodes as well. Thanks again to the British Columbia Institute of Technology students who reached out to us with this idea. We were absolutely thrilled to work with them, and we want to thank them for their time and their effort in recording these episodes for us. We hope you enjoy.
Mikisew Cree First Nation v. Canada, Governor General in Council, 2018, SCC 40. Background. In April 2012, there were two pieces of Omnibus legislation introduced to Parliament which would have a significant impact on Canada's environment protection regime. The Mikisew Cree First Nation were not consulted on either bills at any stage of the development. The Mikisew brought an application for judicial review to the federal court, arguing that the Crown had failed in their duty to consult as the legislation would impact their right to hunt, trap, and fish under their Treaty No. 8 rights. The reviewing judge held they were entitled to be consulted and make submissions. On appeal, the majority of the Federal Court of Appeal held the trial judge made an error. The Federal Court of Appeal held that when ministers develop policy, they are acting in a legislative capacity. Their actions cannot be reviewed judicially. The Mikisew appealed to the Supreme Court of Canada. Supreme Court. The Supreme Court of Canada addressed whether the federal government was required to consult prior to passing environmental legislation that would affect the exercise of treaty and/or Aboriginal rights. In doing so, the court grappled with reconciling two constitutional principles: protection of Aboriginal rights and the title versus the separation of powers and parliamentary sovereignty. Ultimately, the majority of the court determined that the development, passage, enactment of legislation does not trigger the duty to consult.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.